Hello, my name is Dr. Vishwas Devaya. I'm an associate professor at Jindal Global Law School, Sonipat. Today we are focusing on universal origins of intellectual property rights. We begin with the origins of copyright, then focus on origins of trademark, and lastly we'll end with origins of patent law as such. So let's begin with origins of copyright. Origins of copyright can be traced back to early days, but when you look at the early days, a lot of the writing used to happen on leaves and parchments, which basically meant it kind of slowed down replication of works that were actually written down on leaves and parchments. Romans actually practiced a system of dictation that allowed many copies of the same book. In this way, they could actually kind of replicate many books simultaneously by using scribes. But even with this kind of a system, you had a very slow way of actually replicating books, which basically meant the flow of information was pretty much restricted. Subsequently, you had a system of wooden print blocks that were invented in China, but was largely unused in Europe until the 15th century, when there were certain breakthrough in the technology. We had two specific developments in the 15th century. One is the use of paper, which was an important step in towards developing of publishing works. Secondly was the invention of the movable printing press by Gutenberg in the 15th century, which allowed printers to actually make several copies of a literature. This resulted in thousands of books coming into circulation, and all of a sudden you had a spurt in the number of books that were available in the marketplace. Many works that were largely confined to a particular territory or region, because you didn't have a printing press, could now be easily copied in a short span of time. Unfortunately, when the printing press came into being, there was definitely, no doubt, a growth or a spurt in the number of books that were published. Subsequently, it basically meant that there was a lot of flow of information, and it was at times difficult for the royalty to control as to what is being printed. Even the church was kind of concerned as to what is actually being published. As a result of the spurt in the growth of publishing, you had the censorship regime actually coming into play. With the advent of the printing press, there was a challenge to the church and the monarch, as there were many books and literature that were critical to the practices of the church and the monarch. One way of controlling such works, largely censorship. Initially, church prevented a number of heretical works from being published. Subsequently, the monarch used different instruments to actually control and regulate the flow of information. Printers were basically licensed to print certain books for a fixed number of years. These were granted in the form of privileges. Earliest privilege granted in the city of Venice, right? These privileges would usually be granted to printers to exclusively publish a particular book for a period not exceeding 14 years. In England, Queen Elizabeth would grant privileges in the form of monopolies to printers, right? So with censorship, there was a lot of resentment in terms of the kind of people who would come up with literary work, but because it was either critical of the royalty or critical of the church, it wouldn't actually get distributed, because largely the church and the royalty controlled publication of material largely by licensing printers. Then in the 16th century, there was a brainwave wherein Edward VI granted what is called as the Charter of Stationers' Company. The charter basically allowed mostly the London-based printers the power to govern and control the printing of books, right? Instead of actually kind of the royalty or the church getting involved directly in the process of censoring books, you had the stationers' company actually controlling what actually gets published and what actually gets distributed. It allowed them to search for illegal printers and illegal printers and books. Largely, powers were granted to the stationers' company to go to places, do searches, and if they found an illegal printer or a book that was not necessarily allowed to be printed, they could actually confiscate it. They had the seizing power. They could actually burn the books that were not registered with the stationers' company. Right? Further, later on, the king effectively exercised the censorship through the company. So, in effect, you had a chain system wherein the king would actually come into play, and he would largely act through the stationers' company. The stationers' company also benefited as it allowed them to prevent entry of new printers as well as control the flow of information. Printers who were part of the stationers' company benefited largely because they could exclude new printers from entering because they wouldn't give them license. Secondly, they monopolized what was to be printed. So they basically control the flow of information through the stationers' company. Right? The stationers' company, right, created their copyright and kept control of it for themselves. Right? The first English copyright, the stationers' copyright, was largely a private law copyright. It was defined only in the ordinance of the stationers' company. Registration of the book's title was absolutely mandatory. From 1662 onwards, they had passed a licensing act which required anyone who wanted to publish book to get a license before it gets printed and distributed. This kind of ensured that there was a perpetual monopoly. There were policies to avoid competition. But subsequently, by the end of 17th century, that is in 1694, the powers exercised by the stationers' company were basically not renewed by the parliament. This largely kind of ensured that the control or monopoly over the printing press came to an end. In 1709, they formulated what is called as the Statute of Anne, which was passed by the English Parliament that recognized the rights of the author. This was the earliest legislation on copyright, basically. Right? What was the form of Statute of Anne? If you look at the Statute of Anne, basically came into existence or force in 1710. It was largely aimed at encouraging learning. It started to vest rights in the author to print and copy their own works. It basically protected the publishers by protecting whatever they published for a period of 14 years. The author's exclusive right was largely for a period of 14 years, but it could be extended to a second term of 14 years if the author was alive by the end of the first term of 14 years. Subsequently, any previous work, that is, any work that was actually written prior to 1710, that is before the Statute of Anne came into force, was also kind of protected for a period of 21 years. So Statute of Anne was largely aimed at striking a fine balance between the author, publisher, and the public. Right? It largely was based on the fact that if you encourage the authors, give them protection for a certain period of time, they'd come up with wonderful literary works. It sought to protect the interest of all three stakeholders: the printers, the publishers, and the common public. Yeah? But with the Statute of Anne restricting the term of protection to a period of 14 years, there was also a battle of what is called as the booksellers. The battle of booksellers is a fairly important development that happened at a very early stage of Statute of Anne. Largely, the booksellers who were based in London were completely aggrieved about the duration of the protection. They felt that the moment a book fell out of protection, there would be competition for them. Largely, they anticipated that the Scottish printers would begin printing these books, and this would hurt the sales of the London printers, who had so far maintained a monopoly for a number of decades. Booksellers argued that common law recognized a perpetual copyright in the author, and there was no time limit at all. And the Statute of Anne, by actually prescribing a time period for the protection of author's work, was completely against the common law principle. They also argued that an author could assign the copyright in the book to the bookseller through a contract, which was not specifically mentioned in the Statute of Anne. Multiple cases were filed in the courts, some of which are basically Miller versus Taylor, Midwinter versus Hamilton. But the most important of all the cases is something that we will touch upon in a couple of minutes. The battle of booksellers continued. The London booksellers argued specifically for perpetual copyright on the basis that authors will no longer have incentive to create new work if they do not enjoy protection in their work beyond their lifetime. Any limitation in bequeathing the rights to their family or estate would be a major limitation that would prevent authors from coming with new work. The Scottish booksellers, though, argue that perpetual copyright would actually keep the knowledge in the hands of a few, and this would impede the flow of information. They argue that this is nothing short of actually going back to the Dark Ages. Right? So the most important case that was fought during the Battle of Booksellers is known as Donaldson versus Beckett. The booksellers were dissatisfied that the Statute of Anne only allowed for a monopoly period of 21 years for works that were created prior to Statute of Anne coming into force. If perpetual copyright ownership was allowed, then works written by Shakespeare and others would actually allow the printers to maintain their monopoly. They argued specifically for perpetual monopoly, and stating that common law actually recognized such a right. But the House of Lords actually dismissed the case and confirmed that there is no perpetual monopoly with respect to works that are written by authors. They said works beyond 21 years would actually be made available in the public domain for everyone without any restriction at all. This decision allowed a number of famous works like that of Shakespeare to be made available in the public domain. Right? So thus started the modern copyright law. Then you had in 1886 the Berne Convention, which allowed for protection of literary and artistic works. Subsequently, you had the TRIPS negotiations, and you had trade-related aspects of intellectual property rights. You also had the WIPO Copyright Treaty in 1996. With that, we end the discussion on origins of copyright law. Now, we specifically look at the origins of trademark law. Let's look at the early days discussion about trademark as such. The ancient Greeks largely kind of used certain kinds of symbols and marks on their artifacts and potteries, largely to kind of indicate that it came from a particular source, from a particular king as such. The Egyptians subsequently used symbols on their structures. The Romans went one step ahead and started using symbols on certain products like bricks. So largely you would find symbols and marks on swords, potteries, etc. For instance, the sword manufacturers in England were specifically required to use symbols to identify the makers. If there was a defective sword, it could actually be traced back to the maker. Later on, marks actually came to be associated with merchandise makers as trade increased. Right? Then the trademark system actually kind of takes a turn in the Middle Ages when the guild system started. with the emergence of the guild system in the 14th and 15th century, the guilds were always concerned about the risk of counterfeits and the impact it has on their reputation. So they insisted on all the members of the guilds to kind of use marks, and these marks would act as source identifiers. That is basically who actually within the guild made these particular products. All the members of the guild would require to identify themselves, right? So if they baked a bread, they would impose a mark that will indicate the guild, that will indicate the street, that will also indicate who actually within the guild made it, right? This enabled the guild members to actually trace back a particular product if it is defective and punish the person for not maintaining the quality. Now, the guilds and marks, right, were largely kind of practiced widely among the London bakers, right? It was very popular among the London bakers. They would generally use these marks on whatever they baked. Largely, guild marks protected the goodwill of the guild, but not necessarily that of the individual trader. So you could basically look at the early marks as some kind of a mark to represent the quality of a particular guild. There were harsh punishments imposed on people who were involved in counterfeiting, and there was very important cases that actually emerged during that time. One of the important cases was that of Southern versus Howe, where a cloth merchant who had been using a particular kind of mark on his cloth brought a suit before the court saying that another person was actually kind of used his mark on cloths which were actually of inferior quality, and as a result of it, it kind of created deception in the minds of the consumers. So this was probably, you could say, one of the earliest cases related to trademark infringement and passing off. Subsequently, you had a very important case called as the Sanfords case. Here the plaintiff sold clothes with the mark JD and had developed a reputation for quality clothes. They used these marks on handkerchiefs, woolen cloths, etc. And for a number of years, they had gained reputation for quality. Now, the mark JD meant or represented a certain quality, right? Customers and traders would actually buy clothing with these marks and would specifically ask for these marks, clothes with these kinds of marks. Now, this basically meant that they largely relied on the mark JD, which kind of represented a certain kind of quality, which kind of told them that it originated from a particular place or particular manufacturer. Unfortunately for the plaintiff, the defendants deceitfully used the same mark JD on the clothes, but the quality of these clothes were much below, and they used it for a period of 2 years, which actually resulted in the slump in sales for the plaintiffs. Basically, the plaintiffs could no longer sell as much volume of their clothes because customers actually thought the plaintiffs were started to make low quality clothing as such, right? As a result of the defendants' low quality, kind of became really difficult for the plaintiff to sell their products in the market. So they actually brought a case before the courts wherein they claimed that the defendants were actually trespassing. Now, the court allowed the plaintiff to recover the damages for interfering with the plaintiff's property. So this was probably an instance where the court recognized that for the limited purposes of trade, there was an instance of recognizing these marks as property, right? Subsequently, you had what is known as Blanchard versus Hill. Plaintiff claimed he had exclusive right to use a particular kind of mark called the Mughal marks on playing cards. The exclusive rights emanated from the charter granted to card makers. Now, the court failed to recognize the rights coming through the charters, as it believed the intention behind the issuing of charter itself was illegal. Then you had another case which is well known for trademark law, which is known as Sikes versus Sikes. This was an English case where the courts had the opportunity to decide the right to use a mark in 1824. Plaintiff basically complained that the defendant used their mark Sikes on his product, which resulted in the drop in sales. The court agreed that the defendant was relying on the reputation of the plaintiff to sell his goods. Subsequent cases were brought on the basis of deceit, that is, defendant defrauded the plaintiff. So, in a number of instances, trademark was recognized as a property, and in the initial days, you could bring in an action of trespass or an action of deceit. But later on, once the court started recognizing trademark itself as a property, origins of all the litigation would entirely be based on the fact that trademark is a well-protected property. Right? Subsequent developments were also found wherein it was immaterial whether the defendants knew about the mark's existence or not. That is, if a mark had gained reputation and the defendant used that mark, regardless of the fact whether he knew that it existed or not, would be immaterial. This was covered in Millington versus Fox. Subsequently, courts also recognized actions on the basis that there is property rights in the marks and not merely on the basis of deceit. This was actually recognized in leather cloth versus American leather cloth. Further, you had a lot of statutory developments like the Merchandise Marks Act in 1862, which allowed traders to actually bring action on the basis of deceiving the owner of the mark. Subsequently, you had the Trademark Registration Act, which was passed in 1875. Then you had the Trademark Act in 1905, which provided for registration of marks based on the intent to use. This was the first time you would allow for registration of trademark based on the intent to use. It allowed for applications to be filed and introduced a system of examination of the marks. Right? Now we conclude the origins of trademark and begin the origins of patent law. Right? Early monopolies related to patents could be found in 500 BC, wherein the Greek monarchs would actually grant a couple of years of monopoly for making new dishes. Then you had a system of guilds that came into play in the Roman Empire, and these guilds were actually granted a certain amount of monopoly. Subsequently, as the guilds started to grow and trade started to increase, you had a system of apprenticeship model where the guilds would actually recruit someone, teach them about a particular craft, provided that the person who is trained actually remains within the guild. You had the Venetian glass makers who followed this model and largely were able to come up with quality products. As reputation increased, the guild brought in a number of rules and restricted the members from disclosing the art to others, largely because you didn't have a system of protecting the technology as such. So early monopolies, as you could see, were not necessarily meant to protect individual innovations. Largely it was meant to kind of protect communal properties like that of the guilds. Right? The genesis of the patent system can actually be found in Florence and Venice. It is ambiguous whether Florence or whether Venice granted the first patent, but records kind of demonstrate that a boat maker who had come up with a vessel that could actually haul heavy material over the waters was granted a monopoly for 3 years in the municipal city of Florence. Right? Subsequently, Venice came up with a patent statute in 1474, which was largely meant to encourage talented individuals to come up with new inventions. The statute basically envisaged a system of registration on the basis of novelty. Infringers were actually made to pay a fine to the inventor. The other kind of development that happened alongside developments in Italy was basically the developments in England. Now, in England, there was a practice of granting royal charters and letters patent. These letters patent basically were open directives given by the kings declaring that a particular person has been authorized to have a monopoly over a particular product, and no individual in the society can interfere with such monopoly. Right? These earliest letter patents could actually be traced to 12th century AD. Gradually, monopolies were granted to guilds who had exclusive rights to sell their products with a particular region. But subsequently, as the trade increased, individual monopolies was being granted, and after the letters patent, you had a system of the monarchs actually coming up with what is known as privileges. These privileges were basically short of monopolies that were granted to individuals who introduced new technologies in the country. With the increase in competition from continental Europe, it became necessary to allow foreign artisans to practice their art in England. Artisans were granted privileges wherein they could practice their art for a particular duration. But they were required to train locals in that duration through the apprenticeship model. So you could have a person of foreign origin coming into England who would be granted a certain monopoly for a certain period of time over a particular product, and that foreign person would train the locals during the period of monopoly. Numerous letter patents were issued largely to ensure that England could compete with the continental neighbors so that it could actually increase the revenues through taxes. Then you had a period wherein Queen Elizabeth started granting these letters patents and monopolies in huge numbers. Largely this was because of the fact that the monarchy did not have a lot of money, and one way they could actually keep the nobility faithful to them was to kind of grant these monopolies. Some of these monopolies would actually be granted over stuff that is already in existence. For instance, monopolies were actually granted to making of playing cards, to making of salt, etc. All these practices were already in existence. People knew how to go about it. But these monopolies or privileges were granted by Queen Elizabeth largely to keep her nobility happy. Right? But with the abuse of these monopolies being but with so many monopolies being granted within a short span of time by Queen Elizabeth, it basically resulted in artificial increase in the price of goods, which actually led to a lot of people being discontented. This largely kind of resulted in a very well-known case called Darcy versus Allen. This was a case wherein Queen Elizabeth had actually granted monopoly over card making and selling of playing cards to Darcy for a period of 12 years, which was further extended. This basically meant others who were already involved in making playing cards could no longer make the playing cards. Right? So Darcy actually brought a couple of actions before the court, saying that there were several card makers who were actually kind of infringing on his monopoly rights as such. But when these matters actually came up before the court, there were arguments made by defendants wherein they said these monopolies were basically restricting innovation, and more specifically, a number of these monopolies were granted to things that already existed. As a result of this, it would basically mean that the monopoly would increase the prices, because there would be no alternative player in the market or competitor in the market, and as such it was detrimental to the public. But Darcy argued that these monopolies were common law rights and it should be continued as such. But the decision in Darcy versus Allen is not material for the purposes of our discussion. What it did was basically set the base for what is today called what was then called as the Statute of Monopolies. When Queen Elizabeth gave way to King James, a lot of complaints came to King James, who kind of very clearly mentioned that he was also perturbed by the fact that there were a lot of monopolies actually being granted. Some of them were really, really perturbing. As a result of this, the Statute of Monopolies was subsequently formulated by the Parliament in 1624, and the monopolies were largely to be granted on the basis of novelty and for a period of 14 years. This was basically the genesis of the modern patent law as such. Subsequently, after a 150-year period, it was also kind of required that any inventor who wanted to claim a monopoly had to kind of specifically file for a specification that included a written description as such. So with that, we conclude the genesis of the patent system as such. To conclude, I'd say we have kind of discussed the origins of copyright, the origins of trademark, the origins of patent law as such, and we have kind of seen the developments from the early days to the Middle Ages, where largely property rights and intangible works started to take shape. Thank you very much.